Mr. President, what would a great corporation do? One that is just so identified with America that new parents trust their products and the work they do with the health of themselves and that brand new baby. When you think back, for many of us, when we became fathers, there was hardly a time when we didn't have, holding in our hands, Johnson & Johnson's baby powder. It clouded the room as we sprinkled it all over our babies and knew that it was just the right thing because others before us, other generations, had used the same product. What's a company like Johnson & Johnson to do then when it turns out that there was an ingredient in that talcum powder that was dangerous? Asbestos. Literally, asbestos. Well, it turns out they knew about it. They knew there was asbestos in Johnson & Johnson baby powder long before the lawsuits were filed. So what does a corporation worth $400 billion, maybe $450 billion do when they discovered that the product that they'd been selling for generations to trusting American families was actually a danger and was now being connected to cancers and mesothelioma? Let me tell you what they decided to do. By way of background, I just want to mention to you, there was a great folk singer in America known as Woody Guthrie. He said there are two ways to get robbed in the world. Some will rob you with a gun, some with a fountain pen. There's a growing sense that there are also two systems of justice in America, and the Johnson & Johnson story bears that out. There's a justice system for rich people, powerful corporations, and then there's a justice system for everybody else. In many days, it seems that the gulf between these two systems is just getting wider and deeper. There's something called the Texas two-step. Used to be just a dance step, but in recent years, it's taken on a new meaning, and it relates directly to Johnson & Johnson's challenge. The Texas two-step is a name given to a highly controversial legal strategy that some of the biggest corporations are now using to shield their assets from accountability. It allows massively wealthy corporations whose product caused harm to avoid paying damages to the victims. Not just that, the Texas two-step denies the victims their right to make their case in court and take their issue to a jury or a judge. And it can stretch the process of seeking justice out for years and years and years while victims get sicker and die. Does that sound like justice? It doesn't sound like American justice. It sounds like somebody getting robbed with a fountain pen. A big law firm that's credited with dreaming up this Texas two-step charges its wealthy client tons of money, reportedly over $1,000 an hour for legal work. It advises large corporations how to pull off this legal maneuver. Well, we received a lesson on the Texas two-step last week in the Senate Judiciary Committee for nothing. The Judiciary Committee's Subcommittee on Federal Courts Oversight, chaired by Senator Whitehouse, held the first ever Senate hearing on the Texas two-step. We heard from experts just how it works. We also heard from one of its victims, Kimberly Naranjo, a mother of 7, who sadly has been given a fatal diagnosis from the deadly lung disease mesothelioma. Ms. Naranjo has been denied her right to hold accountable in court the multi-million-dollar corporation whose product she believes caused her fatal illness. The name of that corporation? Johnson & Johnson. Here's what we learned about how the Texas two-step works now. In a nutshell, here's a big corporation like Johnson & Johnson that's being sued because it sold a dangerous product, or it's likely to be sued for causing harm to victims. Well, they take their corporation and they reincorporate in the state of Texas and execute what's called a divisive measure. They cut their corporation not in half, but legally in half. In a traditional merger, two companies become one. With a divisive merger, it's just the opposite. One company becomes two. The original company keeps all the wealth, all the assets, all the operations. The new company created in this Texas procedure is really just a shell. It receives the original company's debts and liabilities and a small trust fund. The new company then reincorporates and turns around and files for bankruptcy in a jurisdiction where it's hard to get a bankruptcy filing dismissed for bad faith. This bankruptcy filing prompts a stay of litigation by people like Ms. Naranjo. The stay of litigation applies to both the shell company and the original company. So instead of being able to seek justice in a court of law for injuries, perhaps fatal injuries, victims are forced to try to recover from this newly created shell company that was made up in a bankruptcy court. How long does that take? Years. And sadly, for many of these victims, they don't have years. As the victims wait for some measure of justice in bankruptcy court, the original company goes about its business. It has shielded all its assets, passed them on in divisive bankruptcy to a shell corporation. And the good corporation, so to speak, or the rich corporation, ends up with no liability, admitting no wrongdoing. Under the laws of most states, companies cannot move assets around like this through divisive mergers, but you can do it in Texas, hence the nickname, the Texas two-step bankruptcy. So step one, create a shell company and transfer your legal liability. Step two, have the new company immediately declare bankruptcy. So far, 4 major corporations have used the Texas two-step and bankruptcy to try to avoid legal accountability for their own wrongdoing. The case that the subcommittee examined last week involved the healthcare and pharmaceutical giant Johnson & Johnson, the maker of Johnson's baby powder. As I mentioned earlier, how many of us fathers, mothers, kids, changing diapers did it in a cloud of Johnson & Johnson's baby powder? For years, Johnson & Johnson denied the story that its products contained asbestos. We know that substance can cause cancer and mesothelioma. Then it claimed that any amount of asbestos in its baby powder was just too small to cause any harm. But internal company documents at Johnson & Johnson, obtained through discovery, told a different story. They showed that Johnson & Johnson knew of the tests going back decades which found the presence of asbestos in their products. While they were actively advertising the use of this product by adults and to use it on our babies, they knew there was asbestos in their product. In 2018, a jury in Missouri ruled in favor of 22 women who attributed their ovarian cancer to Johnson & Johnson baby powder and other talcum products. The women won an award of $2 billion. Remember that number, 22 women in Missouri, an award of $2 billion. Today, there are an estimated 38,000 people with ovarian cancer or mesothelioma who've sued Johnson & Johnson, alleging that the company's talcum products caused their illness. But Johnson & Johnson's use of this Texas two-step divisive bankruptcy means that these 38,000 cancer victims no longer are able to bring their claim against the company. They've lost their right to have their case heard in court because Johnson & Johnson, this giant company, has created a bankruptcy and a shell corporation that has absorbed all of the legal liabilities of the original Johnson & Johnson. So anybody that wants to sue them now has to get in line in bankruptcy court with all the creditors and alleged victims and wait and hope there will be a day when some fraction of the trust fund that Johnson & Johnson gave to its shell company when it spun it off and loaded it down with legal liabilities may provide some relief. The chances, next to none. Stick with me and do the math. We ended up with 2 companies. Once it was just Johnson & Johnson, and then 2 companies emerged out of the bankruptcy court in Texas. The one company with the liabilities, the one you could actually sue if you could get into court, they created a trust fund for that company of $2 billion. They have 38,000 outstanding claims. 22 women in Missouri recovered $2 billion from them already. So you know that 38,000 people are not going to go very far with $2 billion total. What's left in the other fat corporation, profitable corporation, big corporation in that bankruptcy division? $430 billion. Johnson & Johnson stuck all of its assets into the healthy corporation that can't be sued and left $2 billion for all these victims of its dangerous product. What a cynical move for a company to make against cancer-stricken customers across America. Kimberly Naranjo is one of those 38,000 Americans who, because of this Texas two-step bankruptcy, lost her right to sue Johnson & Johnson. She's forced to wait in line in bankruptcy court. She testified at last week's hearing. Her story is not an unusual one. Ms. Naranjo grew up surrounded by addiction and abuse. She moved from one foster family to another. She had her first baby when she was 19 years old. She used Johnson's baby powder on all 7 of her children. It was, she said, quote, that white plastic bottle that I associated with motherly love. As it happens, that was the same message Johnson & Johnson used in its baby powder ads. They used to say their product, quote, feels like love. Last year, Ms. Naranjo brought her first home. 2 days later, she started her dream job. But a week after that, she felt a pain in her side. She went to the doctor and sadly learned she had mesothelioma. She was told she had 12 to 16 months to live. She knows she can't beat mesothelioma. Nobody does. All she wants is a chance to make her case in court before she dies so she can leave something to her kids. And so she came to Washington to testify before our Senate Judiciary Committee last week, a voice representing thousands of cancer victims who went through exactly what she did, exposing themselves to Johnson & Johnson's dangerous product. I commend her and thank her for her courage. She's fighting for her kids and all the other victims, incidentally, whose voices would be silenced by this Texas two-step bankruptcy. As she said in her testimony, and I quote her, I don't have much time left, but I will not quit. Over the past few months, I decided to write to Johnson & Johnson. This is a company that used to take such pride in their products. I remember all through my life the advertising that associated their products with wholesome, safe help for families. I wrote to the former CEO and the current CEO, and I urged them to change course, back away from this Texas two-step. Abandon this cynical scheme. Hold yourself accountable to the people who trusted your product. I urge Johnson & Johnson to live up to its reputation of being a company that family and consumers can trust. Sadly, they ignored me. This week, a bankruptcy court is considering a motion by talc claimants to dismiss the bankruptcy of the shell company that Johnson & Johnson spun off to unload its legal liabilities. It's a key test of this Texas two-step and whether wealthy corporations can continue to abuse Chapter 11 bankruptcy to dodge their legal obligations to victims like Ms. Naranjo. And it's not just lawmakers who believe, like me, who believe that Texas two-step can deprive victims like her in court. Listen to what the author of the Texas Divisive Merger Statute, Steve Wollins, said earlier this week about the law that brought the Texas two-step to life. And I quote him, had we known in 1989 that the provisions could be dubiously interpreted for entities to avoid known liability, such as those causing severe and permanent injuries and death, the law would never have passed with the Texas two-step provision. Never, never, never. Mr. Wollins also said, and I quote, shame on Johnson & Johnson for trying to evade its liabilities for products it sold with its golden stamp of approval for safety. Mr. President, when a legislator like Mr. Wollins publicly states that the major company is intentionally misusing the law he wrote, I don't think there's any room for uncertainty or equivocation. This is a shameful, indefensible strategy on the part of Johnson & Johnson. I hope the courts reject Johnson & Johnson's abuse of federal bankruptcy laws, but I also believe that Congress needs to do something. We need to close this loophole for good. In July last year, I joined 2 of my colleagues, Elizabeth Warren, Richard Blumenthal, in co-sponsoring legislation which would rein in various bankruptcy loopholes like the Texas two-step. I'm committed to working toward this goal. I hope Democrats and I hope Republicans can work together on a bipartisan basis to stop this bankruptcy abuse. Bankruptcy is supposed to be a good faith way to accept responsibility, pay one's debts as best you can, and then receive a second chance. Not a Texas two-step, get-out-of-jail-free card for some of the wealthiest corporations on earth, like Johnson & Johnson.